Welcome back. It's Hard Factor 91.3 Nigeria Info and here in Port Harcourt. I'm Dio. 11 minutes gone past 4 p.m. Conversation continues. Thanks for staying tuned. And the matter we'll discuss in next taken version as reported by the Vanguard newspaper. It's captioned, Sunday Igboho sues DSS, claims 500 million naira damages over attack on house. Well, here's a bit of the story. Legal counsel to Yoruba activist Chief Sunday Adedayo, popularly known as Sunday Igboho, Chief Yomi Aliyu SAN, on Sunday sued the DSS for attacking and damaging his house, alleging that the DSS operatives went with the intent not to arrest but kill him. Now, this came on a day Lagos Police Command said 49 persons, including the suspected leader of, a suspected leader of a Bonicon fraternity and a female Oshun worshipper, were arrested during the botched Oduduwa Republic mega rally at the Ghanaian Fire Freedom Park, Ojota, in Lagos. Now, back to the original story. Sunday Igboho's counsel, Chief Lee, in a statement, described the invasion as illegal and unconstitutional, adding that the accusations leveled against his client were false. Now, he also urged the federal government to probe the invasion, to sanction the DSS operatives, free all the people arrested, and also demanded the payment of 500 million naira to Igboho as compensation for the damage to his exotic cars, including a Mercedes-Benz G-Class and 2019 Lexus car, among others. Our statement read in part, quote, we are counsel to Chief Sunday Adedayo, otherwise known as Sunday Igboho. We have his standing instructions to defend and act as his counsel in all situations we deem appropriate, especially where his fundamental rights as a citizen of Nigeria is violated or threatened, as done on Thursday, 1st July 2021. Every Nigerian, albeit the whole world, is aware that in his open crusade for the establishment of Oduduwa Republic, our client has always preached peace and warned his followers never to have recourse to violence, saying that it is God that will fight for the Yoruba nation. Moving even further down, we were reliably informed that the DSS and other security forces invaded the residence of our clients in wee hours of the day between 100 hours and 4:30 hours. There is nowhere in civilized world that a citizen who had no prior invitation by security agents or resisting arrest will be so invaded with his rights to dignity of human persons, ownership of property, and sanctity of life trampled upon during the invasion. Now, the statement does go on and on, but we'll leave it at that for now. Also, they say we hereby demand that the federal government orders an investigation into the actions of the various security operatives led by the DSS that raided Chief Adedayo's house, to sanction them and release all the innocent people arrested and compensate the families of those murdered. Our client should also be paid 500 million naira as reparation for damage to his exotic cars. That includes a Mercedes-Benz G-Class and 2019 Lexus car. We also demand a public apology. Most importantly, trampling of our client's fundamental rights, including tagging him as a criminal by exhibiting DSS guns, as his should stop forthwith. Well, that's as much as I can take on the story right now. Several matters to consider here, but I'm also asking the question, might Sunday Igboho have valid grounds on which to make the claims that he's making at this time? And joining me via phone for this conversation, Barrister Ritchard Wokocha, one-time Chairman of Nigeria Bar Association, Assoc branch, and also Associate Professor of Public Law, Rivers State University. Barrister Wokocha, good evening. You're welcome to the show.
Thank you, Dio, and good evening, Nigerians.
Great. So let's go straight to it then. The question I asked earlier on, does Sunday Igboho have valid grounds to make the claims that he is making?
Well, first, anyone who feels that his rights have been infracted is enjoined by the Constitution or authorized by the Constitution to approach the courts for appropriate orders to stop the violation of his rights. So, does he think that his rights have been violated? It does appear he believes his rights have been violated because he believes he has not committed an offense. But if we take the circumstances of the case, the police is alleging, or rather the DSS is alleging, that he possesses firearms illegally and all that. And on the basis of those facts, yes, I think the police would have a right to search or to enter the premises. Otherwise, it would have been wrong, but there is the police right to enter the premises they suspect a crime to be going on, or in which they suspect criminal objects to be hidden that may establish a crime. So there is that right on the part of the police, and for that reason, it is doubtful whether he will succeed in the claim. But as for the claim, anyone who feels that his rights have been violated is entitled to approach the court. That in itself is the advice of the Constitution or the direction of the Constitution.
Does that mean that, does that suggest that if the police or any other security outfit like the DSS, for example, for whatever reason, wants to invade the person's privacy, they can simply claim that the person has weapons of mass destruction, or the person has amassed some weapons, or is in possession of some criminal items which we want to investigate further? Would that be enough of a reason to invade a person's house?
Yeah, that reason is raised. A court will have to conclude whether there were reasonable grounds for their holding that opinion or impression. In this particular case, something was on, which is the rally that was scheduled for Saturday, which the agencies were trying to stop. But again, consider the fact that rallies in themselves do not violate the law. And the freedom of association and freedom of expression, taken together, guarantee citizens' right to hold rallies, subject to the liability for any breach of the law that results from it. But holding rallies in themselves, not an offense. So that alone should not have been an excuse. I guess that's why in their briefing, they try to show proof of the basis of their suspicion by displaying some things which they allege were obtained from the raid.
Now, can the police or the DSS raid the person's home or house the way they did Sunday Igboho without... I'm going somewhere with it, because you mentioned that a judge would have to agree with them. So would they in every such circumstance or instance have to get a judge's backing for them to be able to effect such an invasion? Or are there exceptions?
Judges backing at the beginning. I mean, where you make the allegation, as in this case, that your rights have been violated and they raise the defense that they have raised, you will have to convince the judge that there was reasonable ground for the suspicion for your action to be justified. That is the action of the law enforcement agents to be justified. Otherwise, a raid on a citizen without basis would be a violation of his rights. That clearly is guaranteed by the Constitution. That would be a violation of his rights. So you will have to convince the court that there were reasonable grounds for your suspecting criminal activities to be going on there before you carried out the raid. Then that will justify, or that will be a defense for your action.
So that means that...
Otherwise, violation of the home of a citizen is always an infraction of his rights.
Does that mean that you then have to prove to the court after you've invaded the home? You don't need a warrant before you invade the home?
Oh, it's not in all cases that the police must have a warrant before acting. It's not in all cases. There are circumstances in which the law permits that the police can act to stop a crime that is ongoing. In those circumstances, they are not required to say, hold on, let's go and get a warrant and come back before we stop the crime that is going on. That is the essence of a sting operation, although there are circumstances where they will also be required, in appropriate cases where the law requires that, where they will be required to obtain such leave. So otherwise, where they believe, strongly believe, or reasonably believe, reasonably is important here, because that's the basis of defense. Where they reasonably believe an activity, criminal activity to be going on, there is the power to intervene and to stop that activity and to uncover the criminal activity that is going on.
Now, Go ahead.
Non-reasonability of that action will render them liable to the victim of their action.
What would amount to reasonability or non-reasonability here? Because, like you've said, the DSS did display certain items, guns, AK-47, rifles, and other ammunition, even including what they termed, I can't remember the exact term, simply put, champs, exactly, simply put, including what was termed a local bulletproof vest or something of that nature.
Yes.
So, now, of course, I mean, there is a cross-section of Nigerians who are of the opinion that Nigerian security apparatus is so skewed and biased and not professional that they could have planted even those weapons in Sunday Igboho's residence or any other place for that matter and claim that these were weapons that were recovered. So would it simply be a case of the testimony or the word of the DSS officers against Sunday Igboho, such that if the DSS say we found the guns in his house, then that's a given, the court must accept that the guns were indeed found in his house?
That is part of the challenge. Those who hold the impressions, I'm sure, are thinking that way from experience, general experience in this country on the activities of security operatives. But I think it's better to discuss this within the context of these activities. And that's the context of campaigns, and Sunday Igboho being leader of a campaign and all that. But as I pointed out earlier, there is nothing wrong in a peaceful campaign in itself. The Constitution guarantees that. It is safer to discuss within the context and not to use it in the sense of a general rule. Because, as I said earlier, violation of the integrity of your home is a violation. The Constitution entitles you to damages, or says you are entitled to that. Their action was reasonable. It's their word against Igboho's word, exactly. But how are we going to determine it? It's now left for the judge in this case to determine. It was a raid in the night. There were no witnesses, apart from those whom they will call accomplices or whom they will call part of Igboho's group. Other than that, it was a raid in the night, and there will be no way of telling who really is saying the truth between them. So it's to become part of the responsibility of the judge to determine. If indeed that raid led to the recovery of, of the guns, there would have been a violation of law. There would have been an offense and a basis for their impression. Again, coupled with the fact that a rally was planned for Saturday, which in itself wasn't a problem. But the existence of those guns will mean the existence of the offense of unlawful possession of firearms, unless there are licenses for them, which cannot be for AK-47. So it's their word against Igboho's word, and the court will have to deal with that dilemma.
Are there have been attempts at drawing similarities between what happened with the Sunday Igboho's house raid and the Nnamdi Kanu situation years ago when he was reported to have jumped bail? One of the defense of being put up by his legal team right now is that he actually did not jump bail, and the reason he wasn't available to stand trial or continue his trial was because of the invasion of his home by soldiers of the Nigerian army at that time. Once again, like I said, similarities are being drawn between what happened in this instance and that instance as well. Can you draw similar parallel or similar lines in both scenarios, or are they entirely different?
Concerning the jumping of bail by Nnamdi Kanu years ago, referring specifically to that incident, yes, there are similarities. Because if at the time of the raid on Nnamdi Kanu's house, he was not violating any law or he was not acting in breach of any law, then it would have become unjustifiable unless there is ground to prove that it was otherwise, as I have said, in the circumstances in which such suspicion can be considered reasonable by the court. So yes, there are similarities to that extent. And
would they be?
However, as a defense, you remember that Nnamdi Kanu's, with respect to the jumping and not jumping of bail, the court is not trying Nnamdi Kanu for jumping bail. And he has preferred an excuse or a ground or reason behind his jumping bail. The determination of whether or not he jumps bail is clear. Jumping bail is that you are not available. You fail to report to your trial on a day fixed for it. And that happened over and over. His defense in that respect, the explanation in that respect would have been perfect if he had sent an excuse to say, look, I can't come to court because my life is threatened. That would be different. But what he has done is provide a reason for his jumping bail. And I think that will sound reasonable enough to most people. If he says he was afraid for his life because of the raid that was carried out on his house, and because of that he had to leave the country. That would satisfy anybody who wants to know why he failed to turn up. But that would have been much more so if he had sent word, which would have shown that he was interested in the trial and he was concerned about the fact that he couldn't turn up for the trial, and he's advancing a reason why he is unable to try to turn up for his trial.
Oh, now one of the, like I said a while ago when I read out from the story, one of the from the statement of Sunday Igboho's lawyers is that their client Sunday Igboho was never at any time invited by the police, which they believe should have been the appropriate thing to do. I mean, it wasn't like he was invited and he did not show up, or any such situation which might require an invasion of his home. Would that be a requirement of security outfits such as the DSS, or more so even especially in this case, to have initially extended an invitation to Sunday Igboho before invading his home?
It would be unsafe to conclude that the fact that invitation was not extended before the raid in itself is a violation of procedure. Such days where the need arises are not dependent upon a prior invitation. If you take the example I gave earlier, if the security agencies believe a crime to be going on in their presence or in a particular place where they have noticed that, they won't have to say, no, let's go back and invite the suspect first. If it doesn't come, then we'll raid. Then the crime would have been completed. Part of the requirement for not waiting for the smoking gun, stopping the crime before it can be committed, is that in that circumstance, they can intervene. So I think that is not a legal requirement, a first step legal requirement that will justify the second one. A raid is either reasonable or unreasonable. If it's unreasonable, it renders the state or the agency liable. But if it is reasonable, the court will oppose the ground or reason for the raid. It's not dependent on prior invitation.
Ritchard Factor 91.3 Nigeria Info here in Port Harcourt. Sunday Igboho sues DSS, claims 500 million naira damages over attack on house is what we're discussing right now. My guest, Barrister Ritchard Wokocha, has joined me via phone. A quick break. We'll return shortly. Conversation will continue, and you can be a part of it via the usual platforms. Do please stay with us.
Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817-001-8162. That is 0817-001-8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817-001-8162. That is 0817-001-8162, and let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt.
Listen to me, I said this is a real situation and the government has to do something about it. What are you trying to insinuate? All these people looting Nigeria's money? You think
this is Nigeria Info, in the heart of Nigeria. 92.3, we are Nigeria Info.
Our freedom depends on our proactive responsibilities.
Let's talk, act, and be about development.
With one voice, our potential is realized. This is your number one news, talk, and sports radio station. 92.3 Nigeria Info. I am listening.
We connect you to the world. We connect you to the vicinity. We are Nigeria Info.
Listen to me, I said this is a real situation and the government has to do something about it. What are you trying to insinuate? All these people looting Nigeria's money? You think
this is Nigeria Info, in the heart of Nigeria. 92.3, we are Nigeria Info.
And now, hard facts.
Hard Facts with Dion.
Welcome back. Still had Factor 91.3 Nigeria Info here in Port Harcourt. I'm Dio. We got 26 minutes to go before top of the hour, 5 p.m. when the news update comes on. Before then, discussions continue. However, Sunday Igboho sues DSS, claims 500 million naira damages over attack on house. My guest is joined me via phone, Barrister Ritchard Wokocha. Barrister Wokocha, you're welcome back.
Thank you again, Bayo.
And you're welcome to join the conversation at this time. The lines are open. The numbers are the same: 0817 923 0002, 0817 923 0003, 0817 923 0007 as well. We're live on Facebook.com/Nigeria Info PH, and WhatsApp is on 0809 030 6416. Via Facebook, Kingsley Ogidi goes, for me, there is no justification for the manner Sunday Igboho's house was invaded and people were killed just because he was holding rallies. I was surprised how you justified the DSS action on the round last Friday. Kingsley Ogidi, okay, I don't want to get into that any longer. that went with last Friday. Michael Collado goes, it's a right move in the right direction. Government lacks moral, constitutional and international right to intrude his house. Enough of government of tyranny and tribalism. Let the killer herdsmen all over this country be treated with same cruelty. Destin Ugo goes, let him be very careful. Onyishi Ejiofor goes, police should have invited Sunday Igboho. If refused, then police will take action by arresting him with warrant of arrest instead of invading his house in such a manner. Onyishi, I hope you heard my guest, Barrister Wokocha, when I explained a while ago that if the police, for example, is convinced that you are about to commit a crime or are already committing the crime, they're not going to go away and send you an invitation because the crime would already have been committed. So there are exceptions to that rule. We've got Chris from Rumobia County on the line. Hello, you're welcome. Go ahead.
Yeah, Dayo, good evening.
Go ahead.
Please, I want to find out from your barrister. does it mean that charm is charm a crime? I mean, if I have charm in my house, maybe I'm a traditional worshiper. So does it mean once you find charm in my house, it means I'm now a wanted criminal or something?
All right. Now, I'm sure that the police did not, or the DSS in this case, did not invade Sunday Igboho's house because of charms. Obviously not. However, I think I will permit that question because it has become modus operandi for security operatives, especially the police, to list charms as one of the seeming contraband items or offensive items confiscated in an alleged criminal's possession. So, Barrister, I'll put the question to you. Is it unlawful to possess charms?
Certainly not. Certainly not. Charm for self-protection. It's a charm for self-protection. And as they call it, traditional bulletproof vest. There is nothing wrong with owning a bulletproof vest which protects you from being attacked or shot by somebody. Bulletproof vest is not harmful to anybody. So that in itself, and all the charms that are found there, which are charms found in his house and will presumably be for his own protection, do not violate any rule. If you notice when we talked about it, I talked of the finding of guns. I didn't make reference to the charms because those do not violate any rule. You are entitled to believe whatever you believe and to protect yourself with whatever you can protect yourself.
So why the security operatives? Why the security operatives always make it a point, more often than not, to list charms as one of the, to list charms in the same category of AK-47 rifles, several rounds of ammunition, and usually they end it with and charms?
I think they are trying to win the case in the minds of the public, which is in the court of public opinion, which, as I said in one of my last interviews, is absolutely useless and unnecessary. You find that state departments, police departments issue statements elsewhere in the world, in civilized countries, but you don't find them parading the suspect as they are issuing the statement. That is the suspect, that is the charm, that is the gun. So they don't do that. Whatever you find is for your investigation. You investigate, complete the information you require for convicting the person, and you convict the person in the court. The public trials we do here are absolutely unnecessary and useless. So I think that culture of public trials has given them the impression that it is important to win the thing, show the charm. If we show the charm, to show he's an armed robber, he has guns and he has charms for protecting himself when he goes for operation. They are following the storyline in their head, which is of no consequence to the law. So there are charms there, as they always display, does not make any legal point, does not add any value to the investigation they are doing or to the case they have on their hand. So I think they have just written a wrong script for themselves and have been following that script, but it has no legal value.
Down there from Agri Road, you're welcome. Please go on.
Yes, Dayo, concerning this Igboho case, carrying arms against the government, allegedly according to the government.
Yes.
Don't you think that when somebody forms a group trying to fight a cause, don't you think that among the group there must be betrayers?
There must be what?
There must be betrayers in this group that can be able to pass information to the DSS to make their operation be illegal, or they want it to be. Because I believe a betrayer must have been leaked information to the DSS. That is why the DSS quickly take action without waiting for what warrant or no warrant.
Daniel, that's highly speculative, but highly speculative. But like my guest has stated, you don't even need a betrayer. You don't need a Judas, if you don't mind the expression, to be in his camp. If the security operatives are suspicious reasonably enough that either a crime is going on or about to be executed, they can invade the person's home without necessarily having a, as you put it, betrayer in his or her camp.
Well, I think that is clear for me. As some people speculate, they don't have right to invade the whole house. And that is where my thought goes to. Thank you very much.
Okay. You're welcome. And also via WhatsApp, Solomon Dakora goes, DSS can go to his house, but they don't have the right to destroy his properties that he legally acquired. Barrister, would this be an appropriate defense that, oh, we didn't know who they were, they came very late, we thought they were armed robbers, that's why we had to defend ourselves? That's assuming that the account of the DSS is the right one, is correct, and actually or factually depicts what transpired, that they were shot at and they engaged in Sunday Igboho's men in a gun duel for about an hour. Now, assuming that did transpire, would self-defense be an appropriate defense here?
It can only be appropriate if you have license for the guns with which you shot back, because it will confirm the fact that you had unlawful possession of firearms, which you were not licensed or supposed under the law to have. So, if you have licensed guns and you shot back with a licensed gun, that defense will be perfect. And even I will agree with you. If I was the judge, I will agree, because it meant run into my house, firing and all that, and I have licensed gun, I will shoot back. I will presume that there are people who have come to harm me, and I will shoot back. So everybody will accept that if I had licensed gun. So if you do not have license to possess a gun, and nobody will give you license to own assault rifle, high caliber assault rifle like AK-47. It's never been licensed. It wasn't licensed. Some licenses were being issued, and nobody will license that. So if such defense is raised, it will prove the fact that they are guilty of unlawful possession of firearms.
Once again, lines still open, 0817 93 0002 or 0003 or 0007 via WhatsApp. Via WhatsApp, a commenter, what does it take to have all police, DSS, SSS officers, I think DSS and SSS are the same actually, officers to wear body cameras when going to high-profile search or raiding? Government will cost and save time when litigations arise, but because government always have ulterior motives, they will not carry out clean security procedure. Now, once again, Barrister, this also raises the issue of trust of security agencies or government agencies in these matters. Is that something that we should be concerned about, and then work out some modalities or systems or processes and procedures through which a higher level of accountability can be got from these agencies, especially when they carry out these actions in the course of their duties?
It would be a good idea, because the concern is a valid concern. As we said earlier, it's become cultural with our law enforcement agents to parade this and parade claim justifications for their actions. So if it were possible to ensure that body cams are provided with which they should carry out operations, that would be perfect. At the moment, I don't think it's a legal requirement here, because body cam is a technology that is not ordinarily easily available here, so it would not have been part of our law prior to this time. But it's something we should grow to, and something that is necessary. It is reasonably necessary. That's why in more democratic and advanced economies, where technology is also more available, it's a requirement, and they use them.
All right, via WhatsApp, greetings, Di. I think there is need to remind some people that Nigeria didn't invent democracy. We copied democracy as a means for governance. Criminal or deviant behavior in those advanced democracies is met with decisive actions. Also, citizens' rights in those democracies is never proven to be absolute. I therefore wonder the way some Nigerians would assume that rights in Nigeria must be absolute, unchecked. Kudos, Richard, Esquire. That's from Emmy Feiraga. Barrister, where do we draw the line here? Where do we draw the line between the rights of citizens and also the duty and responsibility of security agents to ensure the protection of those lives and to ensure the protection of those rights as well? Vis-a-vis, for example, if a crime were to be committed, like you said a while ago, one would not expect security agents to go back to the office first and say, well, we have to invite him, even though they are reasonably convinced that the crime is ongoing. Because like you said as well, I mean, we are also replete with antecedents of security agencies illegally making arrests, illegally invading people's homes, and even planting evidence as well. So where do we draw the line, really?
It's a difficult one. It's been the traditional question that has informed every effort to reform society and reform public processes to be compliant with the rule of law. How to ensure a safe society without sacrificing the rights of citizens. Our experience here has left us with very high deficiency in trust of public institutions, especially law enforcement agents, because of what has become characteristic and traditional with them with respect to their approach to issues. In crimes where it is different, there is a high degree of trust for law enforcement agents, and the citizens cooperate and aid them in every way necessary, looking at them and viewing them properly as they should, as protectors of the citizens. It's difficult for us to say that here. Our experience here has not really supported that kind of patriotism among citizens. And so, where do we draw the line? We resort to the law. The point, and I like the fact that Igboho has taken the step that he has taken. The point is that citizens should make it a habit to approach the court. The funds may not be there, but we may be able to find support with agencies that are willing to promote citizens' rights. Citizens should form the habit of approaching the courts in those matters. And the time the courts compel them in circumstances that are unreasonable, compel them to pay the price for such unreasonable inversions where they are unreasonable and therefore unlawful, they will become more careful, and I'm sure they will occasion some reform to their means and procedure for carrying out such activities.
Via Facebook, Abdul Ganiyu Jimo goes, hello, Di. For me, Sunday Igboho and co are very lucky with PMB's leadership. If it were late Sani Abacha and OBJ era, would they try this? Kudos to our gallant DSS for waking up to their responsibility. You can join the conversation via WhatsApp as well on 0809 030 6416. Via WhatsApp, Sunday Igboho and Nnamdi Kanu are different cases entirely. Sunday never sued to court. Neither Sunday, I think you mean to write, was never sued to court. Neither the case started at all. DSS can search anybody's house if there is a suspected act, but he can never send the person to jail unless the court gives a verdict. On Kanu, the case has started, and he was given bail. Pardon me. He was given, back to the message a while ago, he was given bail based on his health grounds and the conditions on the bail is that he should not have a gathering of more than 10 people, which he flouted. Okay, that's the much that I can make of this. Alright, still via WhatsApp. Hello, Don. Professionally, the DSS and the police were supposed to pick each other of the items recovered in his house with hand gloves in order to be able to carry out fingerprints in them, but these arms were carried out with their bare hands. Thanks, that's some cool. Well, you know, there's a way that we do it here, I suppose. I've got about 10 minutes to go before 5 o'clock. Don't know if I can reconnect with my guest for the next few minutes to wrap it up, or maybe I just go to the phone lines. Well, the lines are still open. 0817 923 0002, 0817 923 0003, 0817 923 0007 as well. The numbers to call. WhatsApp on 0809 030 6416, or go to facebook.com /Nigerian for PH to leave a comment. Hello, hot factor, welcome. Hello.
Yes, I am.
All right, so you're welcome back.
Thank you.
Right, so we have to wrap this up in a moment, though. So, All right, so to the question I asked you, let's go back to the very beginning of this conversation. You say that anybody who feels that their rights have been violated has a right to go to court. Of course, anyone possibly has a right to go to court, but I think there's a difference between having the right to go to court and having valid grounds to go to court. So are you saying anyone can file any matter in court, whether or not they have valid grounds to do so? Hello, Barrister.
Hello, Dayo.
Yes, you were saying a while ago that Sunday Igboho at the start of our conversation.
I heard you.
Okay, go ahead.
Yes, for safety purposes, that is the language of the Constitution. Because otherwise, things could go wrong before you determine whether it's valid or not. Anybody who feels that his right is infracted is entitled to approach the court for a declaration, including necessary declarations stopping that action and making any others that he prays the court to make. It is eventually for the court to determine whether your rights have actually been violated or not. There have been several cases where people have done that. I have prosecuted matters in which attempts were made to stop them, and the person ran to court and his rights are violated. And the court looked at the matter when facts are presented and said, no, this has nothing to do with your fundamental rights, and there is no violation of your right, and the prosecution will have to proceed. And so that is the language of the law, and I think that is safer. It's global standard. If you feel that your rights are infracted, instead of you to resort to self-help, approach the court. The court will stay all actions and look at the matter and determine whether or not whatever is going on is lawful or unlawful.
Now, a question here also via WhatsApp, which I think we might be wrapping up this conversation with. Was Sunday Igboho right to have escaped from the law enforcement agents? Couldn't he have surrendered if he had nothing to hide? That's from Ben.
Yeah, surrender is, well, yes, you can say so. But again, didn't they have something to worry about if they were shooting? I think anybody in his position would have sought safety first before thinking, what if the invaders were even some unknown gunmen? What if they were some unknown what we give all kinds of names? What if they were just assassins or robbers? So I think it is reasonable of him to have escaped. He did not violate any law in escaping in this circumstance. He was not resisting arrest. That was not a conventional and regular arrest. So anybody in his position is entitled to first seek preservation of life, which is a natural rule, before any other thing. So I think we cannot sort of blaming him for not surrendering if he knows he was not doing anything wrong. He had the right to preserve his life and to protect himself.
We'll wrap up the conversation on that note then. Thanks to my guest, Barrister Ritchard Wokocha, past chairman, Nigeria Bar Association, Assoc branch, also associate professor of public law, Rivers State University. Barrister Wokocha, many thanks for your time.
Always our pleasure, Duchess.
We've got top of the hour, the news update coming up at 5. After that, we'll delve into some other matter. Said matter, by the way, has to do with National Assembly taking a stab at the electoral bill, reversing hopes for electoral integrity. When I return, do please stay with us.